Speech is one of our fundamental rights that we have. If it is a fundamental liberty issue, a fundamental right, they must narrowly contain that. They must issue something in the narrowest possible manner. When you have these gag orders that come out, they are not narrowly constrained. So basically, on their face, they are unconstitutional. Again, what I would say, and again, not being an attorney, can't give any legal advice, even though our attorneys give religious advice and psychological advice, and they're not priests or pastors, and they aren't psychologists. They give it freely, but we can't give legal advice, and I'm not giving any legal advice. What they've said is that you must consider a least restrictive measure. You just can't make it overly broad. The substantive evil must be extremely serious. The order cannot speculate. Well, if we don't put this gag order on, perhaps the interests of the child will be hurt. That's speculation. You cannot issue a gag order based on speculation, what might happen. It might hurt the children. That is complete speculation. It might cause an invasion of privacy. That is speculation. It's speculation, and I believe that those orders should be objected to, and they also should be, you mentioned ignored? That's the same way I look at them. You know, that's what Jeff Younger does with the gag orders that he has. And Jeff Younger has said, Jeff Younger is the man whose judge wants to chemically castrate the son. And Jeff says, come on, you've issued this gag order upon me, put me in jail, find me in contempt of court, because I will take this to the Supreme Court and we'll see who wins. And the judge won't do that. Why? Because she knows in her heart it's unconstitutional. That's what I think, but I don't know that for a fact. I'm speculating here.
I just had a lady message me, her sister in Louisiana, I forget the parish. She stood up and told the judge that the gag order is unconstitutional, and he said, fine, I'll put your ass in jail. And he had her put in jail.
Yeah, there's a lot of things that these judges do that that's a whole different issue, but I know what you're saying. The judges act, they are rogue judges. The judges are state actors. They need to be constrained by the Constitution. Family courts, we've had people tell us, family courts, you have no constitutional protections. They do not apply in family courts.
Yeah.
And judges, they act as if they are judge gods. So we have a different remedy for that, but for whatever that may be.
I was reading something the other day, and it says it applies to all courts, civil, except family. I mean, why is that?
Well, what is a family court anyway?
Huh?
What is a family court? It's a made-up court.
Yeah.
It's a place where opinion becomes law. Well, the judge thinks that. The judge has no
Family court is a civil court.
It is a civil court, yes.
Yeah.
But they don't follow a lot of times civil procedure.
They don't.
Yeah.
You got their own set of rules.
Yeah, well, they're rogue people. It's like 1%. And look, I've talked with people at the appellate level. I've talked with people at the Texas State Supreme Court, and they know that there is a problem with the family courts in Texas. But they have to, unfortunately, we have to take a case to them so they can rule on it. We had a friend who did that not too long ago, a couple of years ago, because a judge decided that the mother of the child, he was now having a boyfriend that was her fiance. They were going to get married. She was in an accident tragically and died. And now the boyfriend wanted to have custody of the kid. And this went to the Supreme Court. And at least they shot that one down. But unfortunately, it takes a lot of money to do this. Chris, I think, spent $300,000 to fight this case. But unfortunately, that's the way that our controls work right now, that you have to spend a ton of money. And usually what they anticipate is that you don't have the money, you don't have the willpower, you won't have an attorney that will take you all the way up there to fight this effectively. It's a racket. Thank you for using that word. The gag order must be couched in the narrowest terms that will accomplish the pinpointed objective permitted by constitutional mandate and the essential needs of public order. So I was thinking about this, how we always talk about collateral damage in war. You know, it's okay if we pinpoint a target and we minimize collateral damage. That's always it. We've got to minimize collateral damage. There's no collateral damage. these courts create collateral damage all over the place. They do not pinpoint an order. So by and large, they are largely unconstitutional. They should be objected to. I believe they should be disregarded and ignored. Now, might you pay the price for that? Absolutely. And not everybody has the ability to fight it. I'm glad some people did fight it. You know, I'm not involved in this stuff from a personal level, Larry. I do not want to see these wicked courts around for my kids and my grandkids. What they have done is horrendous. Said they're abusive, and I fight that basically because somebody somewhere has to take a stand and say it stops here, it stops now, to the best that we can. And that's why, you know, my best friends are friends from this movement. We've said no, even though we may have been victimized, we may have survived, whatever, we are here because we are not going to let this continue if we can. And we're going to do whatever we need to make sure it happens. It doesn't continue on. A state actor, such as a judge, does not demonstrate adequate justification merely by asserting that certain speech is an invasion of privacy. Well, if you say something, it might invade their privacy. Doesn't make a difference. They may disseminate inappropriate information. Inappropriate information is a subjective opinion. I mean, I've heard people say, well, you know, you should never talk with your kids about your divorce, about the attorneys. Why not? How do we teach our kids about the corruption of this industry if we're not allowed to talk about it? I remember when my father was going through the divorce that my mother filed against him, and I remember hearing this stuff, and as a 15, 16-year-old kid, I was furious. So, you know, I think it was very important that I learn about the corruption back then, and that was many, many years ago, and I think that we should tell our kids, this is what's going on. But that's my opinion. Inappropriate is their opinion, and they're giving out gag orders based on their opinion. Further, a state's interest in protecting juveniles cannot alone justify suppressing speech about a juvenile's private information that was lawfully obtained. So there's a lot of things that, well, we can't let this go on. If it's lawfully obtained information, you cannot justify a gag order for this. The objective of shielding children by itself, we're going to shield the children, that does not suffice to support a blanket ban if the protection can be accomplished by a less restrictive alternative. The Constitution, Texas Constitution, more robustly protects against prior restraints than its U.S. counterpart, and they go further. The court has applied ordinary prior restraint law to evaluate a gag order in the family law context. Grigsby provides that the broad powers of the Texas family trial courts do not authorize family courts to invade constitutional guarantees. You can't put on a gag order and cite there's some type of imminent harm without citing any evidence. Well, there may be some imminent harm. That's speculation. There's no evidence behind it. In this particular case, the judge basically followed an attorney's recommendation that that there be a gag order and that they would prohibit any further postings on social media regarding the child. So here's an attorney, and I believe that the attorney was representing the Department of Child and Protective Services or something like that, but saying parents cannot talk about their children, cannot post photos about their children. It is absolutely ridiculous. And like I said, I believe, and I'm not 100% positive, but I believe the attorney probably was representing the Department of Children and Protective Services. Again, this, because they did not object during the course of the proceedings, the Texas Supreme Court could not hear this, but the Amicus Curiae kind of, to me, it's like, here's the roadmap for the future. You can do this to the Pardos, and by the way, if you're listening, here's what you need to do to stop this abusiveness. The gag orders are by and large unconstitutional. They are restraints on free speech. Juvenile privacy justification is not a compelling interest.
So was there any final rulings issued on the Pardo case about the gag order?
I don't know, but this I don't, because I don't know what happened after that. This is just what I saw as far as the Attorney General putting out. And sometimes I do pick these things up because the Attorney General, when he gives his opinion, he has case law. I'm not an attorney, I haven't studied this stuff, but it's kind of like they're giving you the cliff, what you can follow and look at for yourself. And the reality is a lot of the attorneys, They don't know the law. And a lot of the judges, I've heard attorneys tell me, that judge does not know the family code. The judge is basically, a lot of times, how do judges rule? Well, this guy here has paid me a lot of money for my campaign and this guy doesn't like me. How am I going to rule? This guy's going to give me another $1,000 for my upcoming campaign. This guy's going to give me nothing. How am I going to rule? Do I want to piss off this attorney that's going to pull his funding from me? No, no, no. That's just the reality of it. And this attorney wants a gag order? Oh, I think I see it. I understand your point. Yes, that's a good idea. It's just a bunch of crap. The gag order that was talked about here, it was unclear, it was untailored, it was unsupported by evidence of effectiveness, and it was not the least restrictive alternative